G'day, it's fugitive Australian journalist Shane Dowling from the website kangaroocourtofaustralia.com. Now, contempt proceedings have been instituted against Friendlyjordies publisher Jordan Shanks and also Troy Stolz, who's a whistleblower who blew the whistle on corruption at Club New South Wales, or alleged corruption. And Club New South Wales is a body that's actually instituted the contempt proceedings in the Federal Court of Australia. We found out on Friday the 2nd of September 2022 because a suppression order was lifted by Justice Yates. Justice Yates had put a suppression order on the contempt proceedings back in July 2022 when Club New South Wales filed their notice of motion to charge them both with contempt. It was also done in an ex parte hearing. So in July they've had a secret hearing, Clubs New South Wales, with the judge, Justice Yates, and had suppression orders put on the contempt application. Neither should have happened. There should have been never an ex parte hearing, nor should the suppression orders put on it. Suppression orders should only be issued in exceptional circumstances. There's a precedent on it, a whole heap of precedents on it actually. The most famous is Reinhardt versus Welker, 2011, New South Wales Supreme Court, Court of Appeal. And that's a well-known precedent, also well known in the federal court. So there should never been a suppression order put on it, and there should have never been an ex parte hearing. They should have filed a notice of motion. That should have been served on Troy Stolz and also Jordan Shanks, giving them an opportunity to prepare for the hearing. But they had a suppression order on it until Friday, so that's a month and a half, 2 months. Now there's a suppression order on it where they couldn't tell anyone. There's a contempt proceedings, but Justice Yates decided to lift the suppression order on Friday, probably most likely because there's a journalist watching the proceedings. It's got corruption written all over it. Clubs New South Wales filed their original application back in April 2020 against Troy Stolz, claiming he gave media confidential information. So they filed the application in April 2020, but they only filed their statement of claim, which is outlining their case, a month ago, back in July 2022, so that's over 2 years, and Justice Yates allowed them to do it. That's what's called a slap lawsuit, where they just drag it out forever, trying to wear the other person down, in this case Troy Stolz, a whistleblower. And there's a whole heap of other evidence that shows that it's nothing more than a slap lawsuit, a strategic lawsuit against public participation, where they try and silence the whistleblower. But there's a couple of key facts in this contempt proceedings. Number one, they had an ex parte hearing with the judge, Clubs New South Wales, should have never happened. Two, they got a suppression order. There was never any exceptional circumstance to justify the suppression order. Justice Yates would have known that back in July, which he confirmed on Friday when he failed to continue with the suppression order. That tells you that he knew there was never any exceptional circumstances. He should have asked him in July, well, what's your exceptional circumstance and why are you approaching the court ex parte? Where's the other party? That's got judicial bribery written all over it. Then add into the fact that it's been going for 2 years and they only filed their statement of claim in July 2022, more than 2 years after they filed their court case. So Justice Yates should have thrown that whole matter out. Yet it's still afoot, and Justice Yates, obviously at some stage, will be set down for a hearing, the contempt matter. Everyone should be extremely worried about it. It's got corruption written all over it. I'm publishing an article with further information on Sunday the 4th of September 2022. That article will be on my website, Kangaroo Court of Australia, so make sure you read it. I'll have plenty of links, further information. I make out the claim that Justice Yates has taken a bribe. It's the only inference you can draw as far as I'm concerned. It's a very powerful prima facie case that he has taken a bribe. If he hasn't, he needs to be justifying, which he can't do, why he's having secret hearings, an ex parte hearing with Clubs New South Wales. Why is he issuing suppression orders when there's no legal basis to on their behalf? And why is he allowing a case to drag on for 2 years, more than 2 years, before they file their statement of claim? It's a national scandal. But I think at this point we need to focus on the contempt proceedings against Jordan Shanks and also Troy Stolz. There's no basis to it. It relates to an interview that Friendlyjordies published, where Troy Stolz was interviewed by Christo Lanka, who's a producer for Friendlyjordies. I watched that video. There's nothing special in it. It's nothing worse than the articles that the Sydney Morning Herald and the ABC wrote based on emails from Troy Stolz, apparently, information that he gave him, where they said 95% of clubs in New South Wales aren't complying with money laundering and anti-terrorism funding laws. So if 95% of the clubs aren't complying with it, that means it's left wide open. And we've all seen other media reports where apparently money laundering is going on left, right and centre at clubs, where they just go in and put a whole heap of money through the pokers and just cash it straight in without actually playing the pokers, and then it's laundered. They've got it from the club, so it's clean. Now, apparently the New South Wales Crime Commission is investigating as well. So Clubs New South Wales' claim against Troy Stolz has got a slap lawsuit written all over it. That's all it is. These contempt proceedings are a scandal. I've been on the receiving of numerous suppression orders, non-publication orders. I've been hit with a number of slap lawsuits from Kerry Stokes. He's instituted contempt proceedings, so I know that area law well. And you have to have an exceptional circumstances for the suppression orders. An ex parte hearing, similar. It's only in extreme circumstances that the judge should be having an ex parte hearing, which is in effect a secret hearing with one party. In the contempt proceedings, have also got corruption written all over it. Justice David Yates has got a lot of explaining to do. How the whole court case is still before the court is beyond me. He should have thrown it out back in July when they filed their statement of claim. He should have said, well, this is over 2 years old. You filed your actual originating claim back in April 2020, and more than 2 years later you're trying to file a statement of claim. No, I'm throwing the whole case out. That's what he should have done. It's a national scandal. But I publish a judicial corruption website, and you'll see many, many articles about that sort of corruption going on. I think it's a federal court, so the new Attorney General should have a good look at it and probably maybe even set up an independent inquiry into what Justice Yates is up to. Other than that, like I said, I'm going to be publishing an article on Sunday the 4th of September 2022. So make sure you visit my website tomorrow and have a look at that article, and they'll have plenty of links with further information. And there's only, to my knowledge, only one other media company, The Guardian, have written a story. They had a journalist there Friday for the hearing. And I'm the only other one who's writing an article or publishing an article and video on this matter. And it's very important I continue to do so on these sorts of issues. So please support my Patreon account. I've just set it up. We've got over 100 supporters at the moment and just under $1,000 a month pledged. And please share this video and my article on YouTube, not on YouTube, on Twitter, Facebook, etc. Other than that, thank you for your time and have a good day.